Administrative Commission.
May it please the Court. My name is Thomas Butler. I represent the father, W.G., in this petition for writ of certiorari. First argument, Your Honor, is that the statutes at hand here, we have Florida Rule of Juvenile Procedure 8.320 and also Florida Statute 39.013.
I'm sorry to interrupt you, but at the outset, are you dividing your time?
No, Your Honor. Thank you.
You don't care.
I believe they do, but they want me to do the standing for now.
When I see in the council table, I like to inquire.
Thank you, Your Honor. We're asserting that the statutes, the language is clear and unambiguous that a parent, such as here where we have an understanding parent, is entitled to the appointment of counsel. Jack objects on that ground. However, we, as just stated, assert that the statute is clear and unambiguous.
So how did the court in CLR go wrong?
We cited cases from the Florida Supreme Court. Bear with me for a moment, please. The Nowles case, and the Polite case, and the Forsyth case, which does state that if the statute is clear and unambiguous, then the court need not go into statutory construction. In CLR, the court jumped to another section in the statute and stated, well, we have parents specified in the statute for appointment of counsel. However, we're going to say they need to be named in the petition, or they need to be a per se party. There needs to be specific allegations.
Let's use the breakdown of offending and non-offending in the petition. Why isn't there a logical reason to differentiate between those and just give the so-called offending parent counsel?
Well, we have these non-offending parents in these cases. There's situations in here where the parent will not have any visitation with the parent through state action. Different from family court. Here we have the state coming and taking the child away temporarily or sometimes permanently. And now with the statutory scheme, not only do we have the offending parent who needs to complete a case plan, but we also have a non-offending parent who needs to complete a case plan. In this case, the non-offending parent, WG, is required to complete a case plan to even have visitation with the child. And this, of course, I believe is a case of great public importance because it will be affecting parents throughout the state of Florida in these situations. The court has jurisdiction over the child in these situations. The court could say, well, even though you're a non-offending parent, you need to complete task A, D, and C, and D, and if the parent doesn't complete those tasks...
It's strictly a matter of the legislature's intent, as expressed in the statute that they enacted and the language thereof. There's certainly a viable distinction to be made between offending and non-offending parents. The question is, has the legislature made that distinction?
Well, our argument is that the legislature hasn't made a distinction.
At each stage of the proceeding under this part, the court shall advise the parent of the right to have counsel present. The court shall appoint counsel for indigent parents.
And my client happens to be an indigent parent. And
unfortunately, in the case involving Judge Biederman, where she ran with the ball the entire length of the football field, unmolested, below at least, when we said that you're not entitled, an absent father or absent parent is entitled to notice, she appointed counsel for the absent parent, and we were not happy about that. That parent was a parent. She appointed counsel, and we reversed. Why isn't that the same? Just the same. I mean, what interest of the parent, your client, is being adversely affected by this proceeding? His parental rights are not going to be terminated. Nothing is happening to him. He didn't do anything wrong. I mean, why shouldn't a parent in a dissolution proceeding in which custody is an issue be entitled to counsel?
I believe that's clearly different, because if we're speaking about a family court action that's separate from the state
I know that's a difference, but why is it a distinction, or is it vice versa? It's a distinction, but why is it a difference?
Well, we have the state coming to someone's home and sometimes physically taking the child away from the hands, and therefore, if the parent cannot see the child for a specified or unspecified period of time based on the court's discretion. And we do have, in Justice Administrative Commission, a response did state that, and which is correct, that the discretion to appoint counsel in these matters should be done on a case-by-case basis. And we are also asking, therefore, if the court could remand the case, so the court could at least build a factual record of the factors that are listed on the Potvin case. And I believe there are two critical factors here. One is the potential length of parent-child separation, and the degree, and another factor is the degree of parental restrictions on visitation. I believe that's clearly impacted in this case. The father needs to complete a case plan, and therefore we are saying that, if an attorney is appointed, then if there is a case plan issue, there would then be an evidentiary hearing.
This attorney who is appointed, of course, will be paid.
Yes. That could potentially bring up another issue, whether the attorney will be paid, and I don't know what Jack's stance is on that issue. And I believe that's at the same time a separate issue.
Would you clear up what it is that the case plan requires the father to do?
I did a late notice of filing, to tell you your honest. I wanted to inform the Justice Administrative Commission of that also. It did list that the father had to do a drug evaluation. It did not specify whether the father was to do a parenting class, but it did say that the father was to have gained insight. And that could or could not be held against the father at some point in withholding or canceling visitation. That argument does come up from time to time in dependency cases.
All right, and there was also some mention of it's not clear to me, the father making a request that custody be changed to him?
In the record that's before us, I am not sure whether the father made that specific request. I do not recall the father making, but I did know that he was very concerned about having visitation.
If he did, that's affirmative relief which he is requesting.
Yes.
It's not something that is being imposed upon him or vice versa by the authorities.
But I do believe.
What is aside from the fact that it's in a different division of the circuit court, which doesn't make any difference jurisdictionally, and that the statute doesn't formally apply to the other division, what is the difference conceptually between a indigent father in a dissolution proceeding who is asking for custody or whatever it is now, a good parenting plan?
I stated the critical difference is that the state action in this case, in the dependency case. And while in a dissolution proceeding we have private parties, and the court and the state could ask the court to withhold any kind of visitation, whereas in a dissolution proceeding, I don't believe that happens.
Do you want a couple of minutes for rebuttal?
Thank you.
Sorry, repeat what the state asked them to withhold.
The state, yes. Sorry to interrupt you, Your Honor.
Say it again.
I'm sorry to interrupt you.
Oh, that's okay.
What the state asked what with respect to visitation?
I believe in a dependency case that the state can ask the court to withhold or cancel visitation.
But are you saying that happened in this case?
No, not in this particular case, but they can. And the father sought visitation and appointment of counsel, and the appointment of counsel was denied.
But he got visitation.
The visitation I don't believe was yet addressed at that particular
Isn't there
time.
still something left of the idea that the court has its own independent interest in the welfare of the child? Isn't that why the guardian ad litem, for example, is permitted to be appointed by the court as an adversary in the proceedings?
Potentially,
And in theory, you don't need a lawyer at all for anyone. As a matter of fact, constitutionally, it probably would not be unlawful not to appoint lawyers in these cases, constitutionally. Isn't that correct?
yes, because there's no per se termination of parental rights at issue at the moment. However, we do have the positive factors that Jack even indicated that should be explored below. We're asking the court.
You guys can't have it. Well, of course you can have it always. That's what you always seek.
Yes, Your Honor. Thank you.
Thank you. Hear from the commission.
Good morning, Your Honor. May it please the court. I'm Christian Lake with the Justice Administrative Commission. The issue today before the court is whether a non-offending parent is automatically entitled to court-appointed counsel in dependency proceedings. Our position is that although non-offending parents are not automatically entitled to counsel, there is a discretion with the trial court pursuant to Potvin v. Keller, and that is based on a series of factors including issues such as visitation, the length of child-parent separation, and any other factor that would be relevant to the court.
Well, what is the statutory authority for your position?
Your Honor, I think the statutory authority is based on the wording of the statute itself. Okay. This is a situation where the statute needs to be read in context. This is the dependency chapter, Chapter 39, is an extremely lengthy chapter that is complicated, to say the least. And 39013 is just one portion of the statute. But even there, you can see the aspect of that this was intended for offending parents, because it starts off by saying stage of the proceedings. And it doesn't say appoint counsel in defense.
If what you say is correct, why is there even any discretion to appoint a lawyer for a non-offending parent? What is the source of that authority statutorily?
That, Your Honor, is before the Supreme Court, and that is Potvin v. Keller. That is at sorry, I have the site right in front of me. But that's Potvin v. Keller, 313 7 2nd 703, and combined with N. Ray D.B. 385 7 2nd 83. And those two cases hold that there is a constitutional right to appointed counsel in two circumstances. One, where the parent is facing permanent termination of parental rights, and second, where the parent is facing potential criminal charges. The court then goes on to say beyond that, the court has discretion to appoint counsel based on these five factors. And those five factors.
And what are the five factors, and where are they statutorily?
They're not in any statute, but they are in the case. And those five factors, Your Honor, are here. I have them memorized, but I apologize.
I don't need to know what they are. I just need
those
to
factors
know.
are.
I don't know where they come from. It's strictly from the case, correct?
They're strictly from the case, but they're still good. I mean, it's a Florida Supreme Court case, and it's still good case law. So, I mean, the Florida Supreme Court has said there is a right to counsel, and the factors that are to be considered are the potential length of child-parent separation, the degree of parental restrictions on visitation, the presence or absence of parental consent, the presence or an action of disputed facts, and the complexity of the proceedings in terms of witnesses and documents. So those are the factors that the court should consider under the discretionary right rather than the mandatory right to counsel that exists for a pending parent.
under the Fifth District case, is there any discretion?
Yes.
There is discretion. Under the Fifth District case,
The Fifth
if there
District
is a
case was
non-offending parent, as there is in that case and in this case, is there any, can the court appoint a counsel who's going to be paid by the state?
Your Honor, and CLR was in a different context. CLR was in a situation where the court declined to appoint counsel at the trial level.
I understand
and the court
that.
defended the trial.
That's this case.
Right, but the difference, and at that point, the appellate court affirmed, and it is the same here, but in this case, the trial court believed that CLR precluded the appointment of counsel
Well, that's
at
what I'm
all.
asking. Isn't that what CLR says?
I think CLR stands to the proposition that a non-offending parent is not entitled to court-appointed counsel under the statute. It never addresses and never talks about Popson or in the GD beyond that context. It looked at it purely from the statutory context. It's unclear. In a sense, it's in the same posture as here. They didn't raise Popson in the trial court here, and I anticipate they probably didn't raise Popson in CLR either. And so what happened is the trial court simply looked at the statutory scheme and determined there was no statutory right to counsel and did not address, and we don't have enough of the facts in CLR to say here. Here, Your Honor, to be honest, it is probable that under Popson, this case would not qualify for appointed counsel because there have been none of the factors appear to be implicated regarding state action.
You're agreeing that it could go back for a determination and the exercise of discretion.
Yes, Your Honor. We believe that would be appropriate remedy because it's generally inappropriate for appellate court to make this type of...
The Supreme Court case was not cited because it was not applicable. It preceded about 4 different changes in the law, which were all outlined in the 1980s by the Fifth District.
That's correct, but Popson was based on constitutional principles. So the legislature cannot take away a constitutional right to counsel, constitutional right to appointed counsel. So to the extent that Popson holds that
So when the Fifth District says this plainly is not a case in which CLR has a constitutional right to counsel if the right exists is purely statutory, the Fifth District is completely...
Well, I think they're probably saying Popson doesn't apply then. But I would also, one thing that also has to be pointed out, Your Honor, is that the distinction between...
Then what is the basis? Your compatriots in the Guardian Lighten's office are agreeing with you completely. But what is the basis of this constitutional right?
Your Honor, it's the liberty interest.
Has ever said that there's a constitutional right to a non-offending parent and a non-offending parent to a appointment of counsel?
Your Honor, I think part of the problem here is that the issue of the line between a non-offending parent and a offending parent has become very blurred. That's part of the problem. That, I think, is probably part of the biggest reason why we as an agency feel that we don't argue with when the courts exercise that discretion. It's because under the new version of the statute, when they amended it back, I think in 2008, to only have one dependency hearing and only have one disposition, basically, they became very difficult for after-the-fact parents and very difficult for anybody to determine whether a parent is truly non-offending or not. In many instances, as pointed out by petitioner, parents are asked to, non-offending, quote-unquote, non-offending parents are asked to complete case plans, and in some instances, the trial courts have even denied custody to a non-offending parent on the basis that they have to do a case plan. They become essentially, even though they are not alleged to have done anything wrong, they are essentially through state action forced to do a case plan.
They violated the case plan. They haven't done anything wrong.
Right, and that's the problem is sometimes that the courts will say, you have to do, to give a good example, you have situations where a parent is, say, has a history of domestic violence. Never in front of the child, not anything that would be a legal basis for dependency. The mother, in that case, does something that causes the child to be brought in the dependency system. The department is likely to deny custody to the father because of that domestic violence history unless he completes a case plan that includes domestic violence counseling, anger management counseling, and that parent would have no legal, that's state action. He maybe has supervised visitation, And ultimately, if he refuses to do the case plan, a year later, it is potentially possible that he could face termination of parental rights based on case plan noncompliance.
Then he's entitled to counsel.
And that's the point. So that's why I'm saying that's what makes it tricky. And that's what makes this line very broad. Here, however, there's really no dispute. This is a non-offending parent with a withhold.
In this proceeding, in this appeal, is there anybody on the other side of this position? Is there anybody arguing, as I have suggested, that a non-offending parent is, as a matter of law, not entitled to counsel? Does anybody say that?
As a per se rule.
As a per se rule? No.
Okay.
No, Your Honor.
And if you look at the, you alluded to the 2008 statutory amendment, which is the part I'm puzzled about, because that amendment was argued to us in a recent case, to the effect that the only pertinent issue is the child detention. We are accustomed to seeing orders that say dependent as to the mother but not as to the father or vice versa, and we're now told that under the 2008 amendment, really that's not the way it's supposed to work. So now you have a non-offending parent, but what the state is seeking is a declaration of dependency as to your child. You're not named as a respondent, apparently, but that it is still a status for the child, and the language seems pretty categorical about appointing counsel. I mean, what do you say to that?
Your Honor, you have a good point. However, it actually still makes a distinction, because if you read further that same statute, it says that there can be supplemental proceedings, basically, although there cannot be another disposition hearing, there can be supplemental evidentiary proceedings as to other parents in the event that there are allegations that would be a tantamount to a dependency to them. So there is still a distinction made between them. Also, under the plain terms of the statute, a non-offending parent is entitled to custody. If the child is out of home care, a non-offending parent is entitled to custody of that child unless the department can show that that would endanger the child. So there are going to be many instances in which, the department has sheltered the child from the mother and has placed the child with the father. And in those situations, there's really no reason for a court-appointed counsel, because the child's with a parent, and the father has no dog in the fight except to argue about custody 6 months or a year later when the mother's done the case plan, and now there's a fight over who gets to keep the child on a permanent basis, which is a common issue.
If there's anything I think we have learned over the past 40 years about these cases, is that the less discretion placed in the authorities, the better. It seems to me that the thrust of the suggestion in Judge Cope's question is that there is always, when there is a dependency proceeding, both parents are entitled to representation as a matter of law. I don't see anything in the statute that says sometimes yes, sometimes no, and it depends on when, where, and how.
Your Honor, part of the concern that we have with that position is that
it could have a very blurred rule, as you say.
Right. Part of the problem, though, I think we see is we can see this leading to absurd results. One of the concerns that we do see is that under the law, anybody can petition for dependency. Although it's typically done by DCF, parents can petition for dependency, including non-offending parents. And if you have a mandatory right to court-appointed counsel for parents, that means the petitioner would get appointed counsel. And that's a risk of, the dependency.
Have you ever heard the response that that's a matter for the legislature?
And, Your Honor, that's a good point, but CLR was decided in a 6-year-old case now. 5 years old. The legislature was aware of it. We, JAT, was certainly aware of it, because we've advocated for since then that non-offending parents, we've argued that issue many times before the trial court, sometimes with success, sometimes with not. Before essentially exercising its discretion.
Again, I see nothing in CLR or in the statute as they interpret it that gives any discretion to a parent. But that's the way it goes. Yes.
But I think what the point I was trying to make, Your Honor, is that the legislature has accepted the judicial construction. They've not amended the right to counsel to make it clear that non-offending parents have that, and CLR has been out there for 5 years.
Why would they do that? CLR has said, that works totally against you. Or against them, who I thought were opposed to you, but apparently are not.
Well, Your Honor, we believe that
the CLR says it's not a constitutional right. It's entirely statutory. There's nothing in the statute that provides for it. Why would the legislature want to change it unless they agree there's nothing in the statute that provides for it?
And, that's the point, but we still believe that Popkin, because it is a Florida Supreme Court case, that has never been expressly overruled, and in fact has been confirmed by the Florida Supreme Court in In Re DB, and as recently as in Re SG, which is in 14 Southern 2nd 228, that, Popkin still remains good law in Florida to the extent that it holds the discretionary right, the constitutional right exists. CLR did not address the constitutional right because it specifically held, as the court has indicated, that there was no constitutional right involved in this case.
I'm sorry, sir, but it did expressly address the constitutional right. It said there is no constitutional right.
You're correct, Your Honor.
Let me just ask a procedural question. With regard to the petition for dependency, is the non-offending parent a respondent, or does the petition only name where there's only one offending parent, does the petition only name the offending parent as a respondent? And I guess that's...
I'd have to look at the petition, but I believe the petition probably names all of the parents because it has to name the parents, but in the allegation portion, it only has allegations as to the mother and as to the father of the other child. There are no allegations as to this father, and that would be essentially, if you look at it, it's on pages 1 and 2 of the petition. It's basically discussing what the maternal grandmother, the father of the other child, and the mother did that gave rise to the dependency in this case. But there are no specific allegations as to the other father. The only reference to him in this is he refers to the legal father of AG and just lists his name with whereabouts unknown. And there's no allegations of abandonment and nothing in here relating to him regarding this child. So there are no substantive allegations in there. He's mentioned as a parent, but that's the only allegations as to him in the dependency petition that I'm aware of. Now, we would concede that in the case plan on page 22, most of the tasks in the case plan for the father are what you would call the standard task for a non-offending parent, that is, maintain stable housing, take child support. There is a task in there that does indicate that he should remain drug-free and submit to a substance abuse violation. I do not know where that came from. That's something DCF may be able to address. But most of what's in there are things that just tell the parent to do what they have to do as a matter of law anyway. I support the child and have, maintain employment, all the things that a supporting parent, non-abandoning parent would do. So those are not really, the only one that's substantive is that one there, and I do not know if that was just left in there by mistake or if that is actually in there for a reason. If that's in there for a reason, that may be a basis to appoint counsel. So that's something that the trial court should explore, possibly explore on the email.
All right. I think we have your position. Rebuttal.
Okay. Thank you very much, Your Honor.
Thank you.
In closing, Your Honor.
You are the father's lawyer.
Correct. In this proceeding, Your Honor.
How did you get to be the father's lawyer?
Well, the issue came up, and since I work in the court, in the courthouse.
You were hanging around the corridor?
Not necessarily, but I'm always in and out of the courtroom.
And they said...
The issue came up, and it was discussed.
But you're not, of course, you're not authorized to be paid for these extremely valuable services.
For this particular case.
Is that correct?
Correct. It's pro bono in this case, Your Honor. Now, we have discussed in essence, when counsel shall be appointed in termination of parental rights cases, as we know.
Could you go back to I want to understand what's in the petition, because I'm paging through it and I'm still not quite seeing it. The petition seeks to declare his child and another child dependent. It states in the petition who the caregiver is. Is WG, is he an actual respondent to the petition?
don't believe he is.
I mean, somehow he found out about this. I mean, I understand he actually came to the hearings.
Yes, I believe he was served.
Well, you came to the hearing too.
This one. But he's impacted, as I indicated, but I believe he was served with notice. He's not necessarily named as a respondent in the case, but he is affected because the court has jurisdiction over his child, and he cannot gain custody or visitation unless he completes the case plan test.
Does the department agree with that? Is he not a named respondent? He is not. So he gets notice, but he's not a named respondent.
But he is a party under the rules. Yeah.
I believe the case law indicates, especially on the Potvin and the DG case, that where there is no threat of permanent termination of parental custody, the test should be applied on a case-by-case basis. And that's
Well, what is the basis for that?
Excuse me, Your Honor?
What is the basis for it? The case says that,
Well,
but the CFR says there's no basis for it.
Well, I disagree.
It's got to be statutory. Where is it in the statute?
I believe where it says parents should be afforded.
And then they're entitled to appointment in every case.
Yes.
What's the basis in the statute for case-by-case, blurred basis?
I believe that this analysis on the Potvin, where there is no...
What is the basis in the statute? There is none, right?
Well, it does indicate in a dependency proceeding that the counsel should be appointed, shall.
For an indigent parent in a dependency proceeding should be appointed counsel.
I believe we do have a dependency proceeding here where the father is...
I mean, if that's the position, that's easy.
Yes, and I believe CLR is wrong. And even if CLR is not wrong, I think that the circuit court, the case should be remanded back to the circuit court to go through these critical factors and to at least have a factual record, because the Potvin and BB cases state that when there's no TPR at issue, which is not here yet, possibly, then the test should be applied on a case-by-case basis.
So the relief you're seeking is, number one, a remand for an appointment as of right under the statute, and in the alternative, a discretionary appointment under the case law that you think was engrafted into the statute.
Completely correct.
Okay. All right. Thank you.
Thank you very much.